accused number 1.
Thank you, my lord. I still confirm my position on behalf of accused number 2.
Good morning, my lord. Van Wijngaard M. with Mr. Oakes for accused number 3.
Thank you. My lord, the matter was postponed today to the date so that we could proceed with the defense case.
Yes.
It will be remembered that accused number 1, Mr. Vanadar, closed his case on the
Accused number 1, yes.
yeah, we closed this case. Today we are going to listen to number 2, because number 1, and number 3 had not witness identification as to whether it's going to proceed or not. So I think my land is going to have number 2 has something to say.
Before getting the panel, just to tie up all the loose ends. On the previous occasion, I think Mr. Potts
That is correct, my lord.
medical certificate was handed.
Yes, my lord.
And the warrant
Was-
still
was-
open today.
that is correct, my lord.
This case would then, otherwise they just curious.
Thank you, my lord.
Do you have anything to say about the absence of accused number 3 on the previous occasion? Easier today. The warrant stood over until this morning.
My lord, I think the court may or court make us
Exactly know what that
yes, because the signal was handed to the previous.
is. Right, no, I know it was, but what happens, we just get into the matter and we forget this and there's still an outstanding warrant, so I want to cancel that warrant.
It's very true.
It is accused number 3 that was.
That is correct, my lord, and I'm indebted to the state for its stance in this regard. Thank you.
I can't recall the last trial date, but it was the year preceding this. On the last occasion, accused number 3 was absent. A medical certificate was handed out to the court by his legal representative, indicating that he had some complications as a result of the operation he underwent, and the court accepted the medical certificate and provisionally, his bail was provisionally disputed, and the warrant for his arrest stood down today. I've raised this issue with the parties, and it seems that the state has no objection to the warrant that was authorized, which is standing down. Be cancelled, and I hereby cancel the warrant for this arrest. Right, thank you. Now, dispense with that.
Well, I have just learned from Mr. Sia, on behalf of accused number 2, that there is something which he wants to formally place on record. Because number 2 was supposed to testify today.
Right. Mr. Lucia?
Thank you, my lord. My lord, indeed, it is accused number 2's case for today. After an extensive consultation with the accused in the very same matter and careful consideration of the merits of the matter, my lord, it is our instructions following our advice that accused number 2 will close his case under the prevailing circumstances, and that the accused does not intend to call any witnesses in that regard. So that will be the accused number 2's case for now.
Right. Mr. Lucia, I don't in any way question what you say. I just want accused number 2 to verify that.
As your lord pleases.
My lord.
Sir, you've heard what your legal representative stated. He spoke to the court in English.
That's correct, my lord.
You follow what the implications of what he's explained to the court, that those are your instructions to close your case.
That's correct, my lord.
Right, thank you. As long as that is your instruction.
That's correct, my lord.
Right, thank you. You may be seated.
Thank you, my lord. My lord, pertaining to accused number 3, we also had lengthy consultations with accused number 3. It's also instruction pertaining to accused number 3 not to call accused number 3 as a witness. Also that we are not going to call any witnesses on his behalf. However, my lord, with the consent of the parties before the court, may I ask that your lordship will accept into evidence, inter alia, the statement in terms of section 112 subsection 2 of the Criminal Procedure Act pertaining to the accused, Mr. Johan Maree, who pleaded guilty, I believe, in the Gauteng division of this court. I will then ask that the contents thereof be accepted and be marked as Exhibit J. My Lord, can we just indicate that the
Yes.
contents thereof are being accepted as correct, not to indicate that that is the actual truth that transpired, but that is the proceedings that transpired in the High Court in Pretoria, my Lord. If I may ask that this be marked as Exhibit J. I believe the last exhibit was Exhibit I.
Yes, what the state's attitude regarding this?
There's no objection, my lord. And so far, that is proceed.
Yes.
My Lord, then pertaining to a further statement which I will be asked that it be marked Exhibit K, is the statement regarding an interview with Frederik Henry Kilian. We'll also ask that this said warning statement be marked as Exhibit K and form part and parcel of the evidential material before your Lordship. That is also by consent. Lordship will note that Mr. Kilian elected not to make any statement in the said warning statement.
Yes.
My lord, if I may say something.
Well, I'm now handed a statement by someone called Mr. Kill. Who is this Mr. Kill? Obviously, I will have to read it, but I'm asking this so that I know what this statement entails.
Our point exactly, my lord. And that's why I asked the court to rise. We also found ourselves trapped in a rock and a hard surface, in the sense that Mr. Killen is not a party insofar as this matter is concerned. He's not a party to the proceedings. But we in any event said to ourselves that we disclosed this as part of the docket to the defense. Now, we just want the court to, I mean the record to reflect that Mr. Killen is not a party in this matter firstly. And whether Mr. Killen will appear before another forum, that is still to be decided, not for now. But it's not a party here in this matter.
But there's been a lot of evidence laid here. Now, this has been sprung on me out of the blue. But if my memory of the evidence is correct, I seem to recollect that the accused number 3's counsel, Sir Benga, who was then cross-examined, at some stage referred to a person who was in charge called Kilia, being a policeman, unless I'm wrong.
Who was in charge?
Of the operation on that night.
No.
Unless
They could have said that.
that is how I'm speaking subject to my memory being correct. That is why I'm asking, who is Mr. Kilia? If it is that person, then I understand what the nature of this affidavit is going to be. Mr. Reinhardt.
My Lord, it is so that...
Right, thank you very much. So there's nothing wrong with my memory. But not my head, not my mind. Yes. What is the state's? The state has stood up and I'm not sure whether you're objecting to the evidence being accepted or not.
It looks like even if I had a choice, it's now needed. I am not going to take it any further, but it's safe to say that we will raise it in our arguments.
No.
That Killian was not the head of the operation.
No. If you don't want to raise it, the court is bound by the laws of evidence. I just don't accept anything. Otherwise, they can come in here and give me an article written by a journalist and say, well, this is evidence. So you must make up your mind, you must elect. If you're not electing, I will then confront counsel for accused number 3 head on this.
My Lord, Killian was not part of the proceedings. We are totally against.
So you're objecting. I don't want to put words in your mouth. I want you to state your case in fairness to the state. Because I'm not certain. It seems as if you have divergent views on this. So you make your election.
My Lord, you're not accepting it simply because Killian was not part of it's not a package.
No, you don't. It's not for you to accept, it's for the court to accept or not. You can object to it being handed in. They want to hand something in, you have, and I was told it by consent. Now, is it by consent? Because if it's by consent, then I know what I'm supposed to do.
My Lord, I rose up to address this issue.
Yeah.
That we are not consenting.
Right. So you're objecting.
Correct.
Right. On what grounds?
On the fact that simply that Mr. Killian is not part of the proceedings. Whatever was stated there was not even tested and so on.
Yes.
He is not part of this.
All right. Fair enough. Let's hear what Mr. Benga has to say.
What pleases my Lord, I'm now taken by surprise because your Lordship, it's my humble submission that we had a meeting with the state.
The meetings between you and the state, I'm not privy to.
Yes.
It's confidential. I don't even want to know about it.
All that I want to
Because all that it will do, it will create prejudice. And I don't want to be prejudiced.
my Lord, I was under
Your meetings is between you people.
Yes, I was under the impression that it was by consent, my Lord. Under the circumstances, it's going to be important for us to prove that specific statement before your Lordship. Under the circumstances, I will then have to bring an application to recall Colonel Beekman, who actually took that statement, in order to come and testify, in order to prove the contents thereof before the court, and then ask the court that it might be accepted as evidence.
Well, isn't it right that you can't just take a statement, hand it up and say, well, the court must accept it, even if the opposite party consents to it? There's things such as hearsay. And what is the purpose of handing in a statement of a person who is not going to be called? What is the probative value of that statement? The whole purpose of handing a statement is, and if you want to have the probative value, it has to be cross-examined. Now, you're not calling this person. That is why I said, even if the state is amenable to this, you can't sit here and invent the law as we go along. This is elementary. It is criminal procedure 101.
Yes, my
It
Lord.
is hearsay. You're handing in a statement of a person you're not going to call. What relevance is that going to be to this? Now, if you had told me that the author of this statement, for argument's sake, is not alive, then you can say, well, we want this thing to be let in through the back door in terms of Section 3 of the Hearsay Evidence Act. Under Section 3, whichever of the subsections there is, more particularly that it's in the interest of justice. You're not telling me that. You're simply telling me it's by consent, and now I'm told it's not by consent. We can't run the courts as if this is now some argument in a Kevin as to which is the better of the football teams. Is it Chiefs or is it Pirates?
No, my Lord, I agree with the court on that, but that is a statement that was discovered by the state.
It might have been discovered by the state. So they've made it available for you. But the way you introduce the evidence, you know the law on
Yes,
this.
my Lord, but that is what I'm trying to explain to the court also. I submit that Mr. Killian did not oppose to any statement whatsoever. So he did not make a statement. However, it is my humble submission that the importance of this statement is, my Lord, and that is the reason why we need to prove that indeed your Lordship will remember when Colonel Beekman testified. Evidence was led pertaining to warning statements that was made by inter alia accused number 1, 2, and 3. It's now quite evident accused number 1, 2, and 3 has also not testified. The importance of this specific statement, my Lord, is to indicate to the court that if Captain Killian, at the time he was a captain in the South African Police, if he was the commander of inter alia accused number 2 and 3.
I knew exactly where you were heading to when you raised this, although the state didn't know.
So
I have my finger on the pulse in this matter, you know.
Yes, my Lord.
So I knew it. But the question is, you're not answering my question. Where is this mysterious person Mr. Killian to to use the opening verse in Shakespeare. There's the ghost. Then the ghost said, the serpent that stung thy father now wears his crown. You see, Shakespeare could use a ghost and he could use an apparition. Courts don't work on that basis. Where is Mr. Killian? Is he alive? Is he dead? Is he, where is he?
Yes.
Isn't that the $64 million question?
Well, my lord, he is alive.
Well, then why do you want to then call the investigating officer to lead hearsay evidence? The best source is the ipsit dixit of the person who used it. There's no sense to say, the serpent that stung thy father now wears his crown, and I draw inferences.
Yes.
Call Killian. Then if Killian testifies that this is so, he'll be cross-examined, and then I can make a credibility finding. Yes, this man is either an honest witness, a reliable witness, an unreliable witness, a shady witness. I can then attach some adjective.
My lord, it is my submission that the purpose, therefore, is not to prove the contents of the said statement. So at the end of the day, the court is going to be asked to make a determination pertaining to the value of the statement. So the court is not going to ask to make a determination pertaining to the contents of the statement. The only issue is whether or not Killian indeed was consulted by Colonel Beertman, and that Captain Killian indeed made a actual warning statement. That is all.
Let us assume Killian made the statement.
Yes.
How does that help me? I don't know whether he was lying through his teeth when he made this statement. I don't know if this is in fact the truth, because he's not coming here to testify. I don't know, for argument's sake, if those are the words that is ascribed to him. He said it.
My lord,
because you see, you are trying to lead something through the back door when the front door is open.
my lord, I submit that is not so. The only purpose of calling Beertman is to indicate to the court that indeed he was consulted and as an accused in this matter, and he elected not to make a statement. My lord, I submit that can never be hearsay evidence pertaining to the issue whether or not he indeed was consulted by Beertman. He was advised of possible charges against him, and he then elected not to make a statement. My lord, I submit.
How does that assist me in the determination of what I'm asked to do?
My lord, and that is the reason why we're also going to ask for a postponement to draft proper heads, because it is our contention that, especially pertaining to the so-called common purpose alleged by the state, that is going to be a very important aspect, which we will deal with, my lord, when we get the
unfortunately
opportunity.
for you, Mr. Weingart, this is not a eureka moment. Common purpose has been alive and kicking from the moment that the accused pleaded. It is not something that came across with the flow of the river, it has been at the source common purpose. Now for you to tell me now we got to sit and think of common purpose is to say something is disingenuous.
My lord, certainly the court must afford us the opportunity, and once again it is my contention, and the court will have to rule upon this. The purpose for which we need to prove the statement, I've indicated to your lordship now what that is, and it is my submission, my lord, it is not necessary for us then to actually rely on Section 3 of the Hearsay Act, because we are not going to ask the court.
You can't rely on Section 3. The person is alive.
Yes, my lord,
you have to call him.
But that is why I'm saying
if he was dead, then there's an opening for you. But he's alive.
I fully agree with that, my lord, but that is not the purpose of placing this statement before your lordship, and we will deal with that in the heads of argument, my lord. So the only issue is which we need to place before the court is that he was indeed consulted pertaining to possible charges which these accused are also facing, and he elected not to make a statement.
Well,
my lord, that is
an objection, and your application for me to accept this evidence, I have to make a determination.
My lord, can I then just indicate, so my intention in order to get the statement as evidence before the court is to bring an application to recall Colonel Beekman, who actually consulted with Mr. Kilian. And I submit, my lord, that is not hearsay. That is not hearsay evidence, because that is not the purpose. The purpose is not to place any.
You know what you're doing in one breath. You want me to make two. You want to kill two birds with one stone. Stick to one issue at a time.
My lord,
The issue is this: if the state had said yes, they're agreeable to it, that would have put the court maybe in a different situation.
I agree with
The
the
state
court.
is not objecting as an objection. I have to make a ruling. Now, it doesn't help you tell me, well, depending on what your ruling is, we'll then bring an application. You can't hedge your bets.
My lord,
if I make a ruling, you can then decide what you want to do.
My lord, it's quite evident that the state is not consenting, so we
Yes.
will have to follow the other route, my lord.
So, the question then is, maybe this is a rhetorical question, whether you agree with the court or not. Because if you agree with the court, then that's the end of the matter, and you can have other avenues. If you don't, I have to make a finding.
My lord, is it now pertaining to the first or the second question?
The question that I must accept this, that
Without consent, my lord.
yes,
Well, the court cannot accept it without the consent of the state, my lord.
right. So then that matter is then dead in the water.
Yes.
Right. So therefore, this is no longer an issue for me to consider. Right. Mr. Wenhart, what do you want to now do?
My lord, then I want to bring an application to recall Colonel Beekman
Right.
pertaining to the taking of that warning statement.
Right. Now, before you do that, and I know what, well, let's give the state an opportunity. They might be very accommodating now. What do you say to that?
My lord, I wonder, the defense is now, they want this court to move in circles, I don't know, because we ought to be finalizing this by the soonest reasonable as we get. But now they are now starting to let us move in circles for no sound reasons whatsoever. Colonel Beekman, my lord, was a witness in this matter. He took a witness stand and he testified and he got cross-examined. Now they are saying they want to recall him. For what? We don't know.
Well, to come and say that
The
man made a statement to him.
My lord, they had a disclosure then, if they wanted to. They had a disclosure then. And I can assure you, my lord, they want to bring evidence through the back door, like the court has correctly said. They is now talking about common purpose. It comes from them. Through him, they now want to lead evidence on common purpose. Through him, they say they want to show the court that Mr. Kane was the overall commander. And that is what we are. We are saying,
Well, sir,
we are saying he was in the witness stand, he testified, they had an opportunity to cross-examine him on all those issues.
you know, I like to get directly to the point. Because running around the mulberry bush just confuses issues. This is not something that the defense is now raising that is unique. And I say this for the following reason. What Mr. Wenhart is doing is obviously wanting to attack the aspect of. This is clear what his intentions are. He wants to go and attack, as he says, common purpose. He raised it. Common purpose, as I said to him, is not something that crystallized as the trial continued. It was something that was available, viable, even before this trial started. In other words, it is something that came about even before they pleaded, because it was mentioned in being charged. Is that right? Now, any lawyer worth his salt, when they talk of common purpose, knows that, well, you've got to prove that the parties acted in concert, and then there's the other aspect you take into consideration, the 5 requirements of Mugedezi. So that would be the genesis of common purpose. Why this was not done during cross-examination when they had the opportunity to show that there wasn't a so-called pre-agreed intent. I don't know. It boggles the mind. One would have expected that to have been put on. And that is why I could still remember the evidence clearly when the name was given to me, that this was mentioned, that he was in charge. Now, to say you let the state's case, the state case had been flowing, they knew what was required. We've moved away. Ages ago, when I practiced, you didn't even have a docket. You came to court, and for the first time you heard the story. That's how we did. Today they're given the docket, they know what witnesses state, they can request particulars, well knowing what the case the state was going to present. And the saying is that they were pre-warned, and one would have expected them to know what is to be done. The man comes into the box, they have the opportunity, they hear his statement, they didn't confront him. Now they want to come. When all the dust is settled, they realize, whoo, we didn't do this. Let us now try and reinvent the wheel. Is that how a criminal trial is to be conducted? In other words, well knowing what is expected of you, you don't do it. You leave it for some reason, and then you say, well, we can now bring an application to reopen our case. What do you say to that?
I'm saying that's exactly my point, my honor. These people had more than a year with Killian's statement. More than a year.
Forget more than a year, they want to have a second bite at the cherry.
Right. Now what they are doing this, they want the federal court now to go outside the criminal procedure and invent a procedure for them which is not catered for in the law. For instance, nothing stops them. Nothing stops them. Killian is still alive. Nothing stops them from saying, my lord, we apply for reopening of our case. We want to leave Killian on this aspect and as whether it's common purpose or it's whatever they want. Nothing stops them from moving such an application.
And I want to place this on record whilst you're arguing. Is they don't want to call Killian because they know that if Killian is called, he'll be cross-examined. So the whole purpose of not calling Killian and wanting to lead the evidence through the back door is to avert cross-examination. Why should I allow such a such a process?
It is within their right to reopen their case, call that Killian, let's cross-examine that Killian.
You know, in 1929 there's a judgment, State versus Herald, that says that a criminal trial is not a game. And magistrates and judges are not umpires. They are officers of this court who are there to see that justice is seen to be done. So I must sit here and just allow people to do as they want to. Forget the rules. Reinvent the wheel. And they've had the benefit, as you say, of the docket. They've had the benefit of Killian's statement. It's not as if Killian's statement was disclosed to them yesterday. And Killian is alive, but we don't want to call him. We want to hand in a piece of paper that can't be cross-examined. And if you don't allow us this, then we want to call the investigating officer to come and give hearsay. He must now say what Killian told him when he is alive. So I must even allow hearsay now. Shocking.
My Lord, if I may answer.
Yes, please do.
It is my submission, my Lord, that the accused number 3's case is not closed yet.
Yes, I know.
So it is not a question that we are now reopening the case of accused number 3. We are still busy attending to producing evidence before this court pertaining to accused number 3. My Lord, we must also remember, and it is my humble submission to this court, that The question is also what prejudice is there for any of the parties, for the state?
You want
At
me
this
to
stage.
answer that?
My Lord,
If you want me to answer it, I will answer it, but I take it's a rhetorical question.
well, the fact of the matter is, my learned colleague did not indicate as to what prejudice there is for the state. And the reason, my Lord, that I am now obliged to call whoever we need to call in order to prove the statement. And it is important to place on record, my Lord, and this is not the first time that the state is doing this, is where before the court starts, that there is an agreement for a statement to be handed by consent.
You're bringing again.
But this is
privilege.
important.
No. You're bringing again disclose what parties discuss between themselves.
My Lord,
is privilege.
the
I
reason-
don't know what was discussed, and I don't want to get
If,
into what was
if
discussed.
the state did not agree to that, my Lord, surely I would not have asked the court by consent to have accepted it. Then we would have followed the procedures in order to call Colonel Beekman to come and testify. My Lord, the question at this stage is, your Lordship says that this is not a game, my Lord.
It's not what I say.
It's
what's stated in a law report.
State versus Harold
AB
says,
decision.
my Lord.
Yes.
That is so. And I fully agree with the court. This is not a game, but it must go both ways, my Lord. So, where the state was in possession of the said statement, it was discovered to us, my Lord. Whether or not we have used it during the state's case, we are now busy with the defense case, my Lord. So, there is not an application to reopen our case.
I know that.
At this stage, my Lord, it is the purview of accused number 3 to call whoever witnesses he wants to call in order to prove whatever he needs to prove before the court. My Lord, and it is my submission, I'm saying with the greatest of respect, the court is wrong when the court says that we must now rely on Section 3 of the Hearsay Act, because that is not the
I didn't
purpose.
say you must rely. I said
The-
if he wasn't alive.
Yes.
You didn't hear me.
My Lord, I
The
did.
question was if he was not. That is why I asked,
Yes.
where is Killian?
But that
We
is
know
not,
Killian is alive.
My Lord-
and therefore you can't rely on that section.
it is not the purpose in order to prove the contents of the statement before the court. And I'm going to reiterate, my Lord, the only reason why we need to prove this before the court is to indicate that he was consulted by Beekman on the same charges and he elected not to make a statement.
Anything else you wish to state?
My
sir?
Lord, that is the actual request before the court, and there is a request to call him. If the court can just grant me a
Sure.
moment. My Lord, and this warning statement was also taken prior to the charges being put to the accused. So the crux of this whole application, my Lord, is only for the court also to know that Killian was consulted on the same charges and he elected not to make a statement.
Yes. Anything else?
That is, yes, my Lord, and that is not, that can never be in dispute between the state and the defense. So surely there is an aspect which is going to be important for the court to know.
Mister, I'm not arguing whether it is in dispute or not. I must be absolutely obtuse not to see that.
Yes.
I'm not arguing with you on that. I'm arguing with you in the manner in which you want to bring this. That is what I'm arguing with you.
Yes, my Lord, and
And I'm saying your request is a novel request. I'm not here to advise you. I'm not your advisor.
my Lord, with the greatest of respect, and I'm saying this with respect towards the court, I don't need the advice at this
Yes,
stage.
yes.
But the fact of the matter is, my Lord, I am of the opinion that I'm correct in order to say that that Colonel Beekman can be called in order just to indicate to the court that he consulted with Killian. Killian did not want to make a statement.
Right, you've set this point in the
Yes, my
beginning.
Lord, and
Anything else?
so the court will have to make a
Yes.
determination on that aspect, my Lord.
Right, thank you. Do you wish to respond?
My Lord, I'm just asking myself why can't the defense not calling this Killian to come and tell us what? Because they are saying, I unfortunately perhaps did not hear them well. I thought they have closed their case. Now
No, the
they-
case is not closed.
If it's not closed, then they still within their rights to call Killian. That's what it is.
Anything else?
Let them call Killian, my Lord, because the court has correctly pointed out what the law says, and that is R versus Hepworth Appellate Division 260. It's quite clear on what they are trying to do.
Yes.
To play games before the court.
Right.
The law is
Let
quite clear on it.
us try and avoid repeating. It's like a dog chasing its own tail. You don't make progress, you just run around in circles. If there's anything else you wish to state that is then new, I'm quite happy to listen to it. Is there anything you wish to state other than that?
Nothing.
Right, thank you. Yes. At this stage of the proceedings, accused number 3 is elected not to, counsel is elected not to call accused number 3 to testify. However, he raised an aspect whereby he wishes to have the investigating officer who testified in this matter before me at least 2 months ago to be recalled to testify regarding a statement made by a certain police officer who I'm told is still alive. And they wish to have the investigating officer recalled to testify. I've heard the arguments in this regard. And in my view, I'm of the view that if the investigating officer comes and he testifies, the court grants a permission, why should he be recalled when this witness has been made available to the state? And they knew of his existence as early as when the docket was disclosed to them. They knew that this witness would come to court and would say whatever he intends to say, X, Y, or Z. The contents of what he would say is not of significance at this stage. But they want to call this investigating officer to come and say so when this person is, I'm told, alive and well. The best person to come and speak on that statement would be the person who made the statement. He is in a position, I take it it's he because I'm told it is a gentleman, that he made the statement, the circumstances under which he made it, whether his rights were explained to him or were not explained to him, and whether, in fact, the statement is a fair and correct representation of what he is alleged to have said or not to have said. Surely, if the statement is there and his signature appears, he is then the author. He is the only person who could testify as to the veracity of the statement. However, the defense chooses not to call him. And it is plain as to why they would not want to call him. Because by calling him, he would be subjected to cross-examination for the court to make a determination as to the credibility of this witness. So in order to avoid that predicament, they choose the second option, namely to call somebody else. That is the investigating officer to say, yes, he made the statement. The investigating officer would not be in a position, firstly, to testify as to the, when I say, the truthfulness of the statement. The only person who could do that would be the gentleman called Mr. Killian. I don't know what his rank is. He's the only person being the author. And the investigating officer, if he testifies, will be testifying as to what this person is alleged to have told him. So to avoid that difficulty and to avoid Mr. Killian from being cross-examined, the defense wants to now lead this evidence once again, not through the front door, through the back door. I'm of the view, and it has been argued, what prejudice can there be? There is always prejudice if evidence is not led in a correct, evidentiary manner. In other words, if the court just accepts hearsay evidence in any trial, clearly there would be prejudice. Yet the author of the statement is alive, and for some mysterious reason, best known to the defense, they elect not to call him, but to call a secondary source. This flies directly in the face of what is known in law as the best evidence rule. clearly the best evidence in this case will be the author of the statement, Mr. Killian. But no, we're not going to call the author. We want to call somebody else to come and testify on behalf of the author. In the circumstances, I'm of the view that this is nothing other than an abuse of the system. I asked counsel at the outset, where is Mr. Killian? Because I thought maybe Mr. Killian is dead. Lo and behold, Mr. Killian is alive, well and kicking. And therefore he can come to this court and testify if he chooses to testify. If the defense is so dependent on that evidence, then they knew from the day the docket was given that Killian was an important witness, because Killian would go to the heart of the matter insofar as, in inverted commas, common purpose is concerned. This is not something that was sprung on them, namely they gave Killian's, the state only made Killian's evidence available to them last week or yesterday. They had it from the inception of this trial in November of 2024 when this trial started. In fact, it is counsel who now brings this application. And I remembered this, and that is why I asked him. I didn't know who Killian was. But I remembered the name Killian being branded during cross-examination, that he was a so-called person in charge of the operation, or one of the senior officers. And I confronted counsel and he confirmed this. So this is not a surprise. In my view, the application brought by counsel on behalf of accused number 3 to recall the investigating officer is accordingly refused.
As the court pleases. That is then the case for accused number 3, Mark.
Thank you. Right. We've agreed upon dates, is that right?
Yes, my lord, we have agreed upon, but I just want the record to reflect to the fact that it is within their right, the defense right. We have never asked for a postponement as a state, and we wanted to hit the ground running today. And that is why we even wrote emails to the defense to ask them about their plan going forward, whether they are going to testify or not. Instead, we got an indication that number 1 is not going to testify and number 3 may not testify.
2 and 3. Number 1 closed this case ages ago.
Number 1 and 3. But 2, it was said that 2 is definitely going to testify. So we prepared ourselves along that line.
Yes.
Only this morning were we then taken by surprise to say he's no longer going to testify. So we just want to, the record to reflect this, that we have never ever asked for a postponement. And we are not saying this court should work on statistics or anything, who asked for a postponement and who did not. We know that the court is the court wants the truth, just seeking justice, whichever way it comes. But we want the court to reflect that it's not our instance, it's not because of us that today now the matter is not proceeding. It's because of what happened this morning after we wrote emails and we asked them to indicate to us whether they're going to testify or not, so that we can plan for today's day. So regrettably, we find ourselves in that kind of a position. That being the case, my lord, subject to the endorsement or the agreement of the court, because the court has the last say on this matter, we have then suggested amongst ourselves that the 22nd day of September 2025 should be the date on which, the last date on which we should have, the state should have submitted their heads. 22nd September 2025, the state's heads must be in possession of the defense. And we also suggested that the 15th day of October, on the 15th day of October, they must have filed their reply. We went on further, my lord, to say subject to the approval of this honorable court, then the arguments will be heard on the 23rd and 24th of October 2025. The accused, I believe, are on board.
The two dates you've given me suits the court, the 22nd September and 15th October. But that is not for hearing. It is just for the filing of heads with inter-parties. The date that you've agreed upon, 23rd and 24th of October, is not available. It's already been reserved. And arrange dates in a matter. I don't know at this stage whether that trial will run or whether the parties are going to have negotiations between them. I don't know, but that entire period, 20th till the 30th, I was told to reserve that date for a matter in the Joburg High Court. I can, at this stage, I must assume that that case will go on. However, I would know about this because that trial starts 4 days early in September. If there's some other, if it falls through the cracks, I can let the parties know by no later than, say, in October, the second week of October, I can let the parties know. Because if I say yes, let's postpone it to the 22nd, 23rd and 24th, and that trial runs its normal course, then I'll be double booked. So we can't, unless the parties are amenable to moving the arguments to be on the safe side, to the first week of November.
That's
You people
fine,
can, then we all know that those dates are cast in stone.
My lord, my situation, with your indulgence, is that I have a party heard before your brother, Procedural, which is supposed to proceed on the 3rd.
1 day of a couple
It's
of weeks.
actually for a period. I do not think that we will proceed for the period. We're already at the stage where the state is about to close its case. But we proceed on the 3rd of November, that very first week in November. So perhaps the second week of November.
Yeah, that's fine. If you're available the second week, I'll
Well,
gladly.
it will procead, but I will then have time to make arrangements for the
Yes,
second.
if you have any difficulty, you can let me know, and I will speak to you.
Yes, thank you.
Prevail upon Judge Stradon to accommodate the court.
Thank you, my lord.
So what do you suggest? The second week starts at 10th of November,
Yeah, I would
which
rather
is a Monday.
Yes.
You give me whatever dates is suitable to all of you.
What, perhaps the 10th or the 11th? No.
Does that suit you, Mr. Weingart?
Is it 12 en 13 glad nie vir julle?
12 and 13.
12, 13. 12 and 13 is
Suit you.
suitable.
And what about
It
you?
does, it does
Suit
suit
you
me,
as well.
yes.
And what about the state, 12th and 13th to argue?
My lord, thank you so much. I was just asking myself whether we really need 2 days.
I don't know. I don't know.
I think we shall have submitted our heads, and I assume the court has gone through the heads, so it will just be to highlight.
I don't want to restrict the parties to argue. That's the point. I have no idea how long we're going to be.
If that be the case, then we will leave it in the hands of the court.
So 12th and 13th. Right. Whilst we at this, we work on the presumption that the parties will argue and the arguments will be completed by the 13th of November. Term ends. th December. I want to wrap this matter up before Christmas. I said to the parties that I wouldn't need more than a week. Because I've been working on this matter. As soon as I get the heads of arguments from both parties, I will resume. So Monday, 1 December, does it suit everyone? For judgment.
It does.
1 December 2025.
Yes, sir.
Does it suit you? Does it suit you?
Suitable, my lord.
My lord, may I just, is it possible to do it maybe on the 2nd, my lord?
Yes, it's fine.
Myself and Mr. Nel, we've got a
No.
matter in
If
Groblersdal on the
if you're
1st.
not available on the 1st, then the 2nd.
Can we make it, if the other
I
part
am
is available
very
on the 2nd?
accommodating.
Thank you,
It will
my
be
lord.
in this year, 2025. Because I've been told to reserve dates in Joburg. That was told to me by the present Deputy Chief Justice who was in the JP. But he's no longer here, so maybe they can change the roster. Because if that case starts, it will run for 6 months. So 2nd December suits everybody.
If it suits the other part.
Right. Finally, I ask this simply so that there's no surprises. All the accused in this matter have been hearing the proceedings up till now in English, and they understood. I'm sure their English is far superior to mine. But I ask this because when I give the judgment, I'm not suggesting they won't understand it. Would they want an interpreter to interpret in Afrikaans, or would we just go in English?
May I quickly approach?
Yes,
Can we do the same?
yes.
It's fine, pertaining to accused number 3 in English.
So they have no objection?
Yes.
They don't need any?
No, my lord.
Right.
In order pertaining to accused number
And
1.
Mr. Moida?
None at all.
Right, thank you. So that dispenses with it. Gentlemen, will you please stand? Yeah.
We've been, and obviously it's at a great cost, we've been having the Africans in Africa coming here and he's coming from far. Can I then assume that he's excused from coming on that?
Well, if they don't need an interpreter, that's why I'm asking this year. There's no point in...
I wanted the record to clearly reflect it.
Well,
So
it's-
it's only on the judgment day, not during argument.
No, well, arguments usually just, record it,
So we can have him excused even.
Forever. I take it you can have him, the interpreter excused for the entire period we've agreed upon.
Yes.
Is that right?
you.
Yes.
Thank you so much.
Right. Gentlemen, this dispenses of the evidence that has been laid in this court. All that is left to be done is for the state, as well as your legal representatives, to file heads of arguments. They've agreed between themselves by which dates they will file heads of argument. The state undertakes to file its heads of argument by the 22nd of September. They will hand their arguments to your lawyers, and then your lawyers have 3 weeks within which to file their heads of arguments. And they will do so on or before the 15th of October 2025. Once they've done with that, the matter is then postponed to the 12th of November. And I have to warn you, each of you, to kindly return to this court on the 12th of November 2025. On that date, the parties will argue as to what they seek from the court. The court has also arranged a date, because this case has been, by then would have been in excess of a year on the road, that it will hand down its judgment on the 2nd of December. Now I want to make it crystal clear to the parties. The court will not accept any dilatoriness from parties. You've given the court an indication that the 22nd September is a heads will be filed by the state, and 15th of October. I don't want the heads coming to me on the 30th, or rather, on the 9th of November, when I must hear arguments. Because between the dates that you've agreed upon by the 15th of October let's say at the end of October, I would have read all the heads and I would have had some idea as to how to proceed with the judgment in draft form. If you hand this to me the night before, it is going to delay the trial, and I can tell you I will take great umbrage at such dilatoriness. The other thing that I appeal to the parties is that I want a hard copy to be sent to me. Because what the tendency is, that copies are sent to my registrar by email, and I'm no longer on the bench, and then I get the thing the night before, and I must sit before a machine, printing out copies, collating them. I'm not going to do that administrative task for you. I insist on each party handing a hard copy to me. I hope everybody understands this. A hard copy is not an emailed copy.
Thank you, my lord. My lord, bearing in mind that you've already retired, where
Yes.
will we now serve
You serve on my register.
on the register? So we'll just make arrangements with her.
I'm sure she will outlive me. All right, gentlemen. Your bail is extended. Each of you, please see to it that you return to this court on the 12th of November, 2025. The trial will proceed on that day. If you're not here, I will insist the trial then proceeds in your absence. Because it's not evidence, your counsel will argue, and the trial will carry on. Unless, of course, there are exceptional circumstances. Thank you.
As the
You
court
may stand.
rules.
As the court.
Leaflet. This is an exhibit, must go to the exhibit file. As I read it here. No, there was a J. Yes, J, K. The accused may stand down. Questions?
Because we didn't get in about these guys. So things like that. So they had 2 homeworks. Yeah, nice. He was trying to think. So down. This time, when you was interesting.
Lepos. Hello. Hello. Is it Uveka? Hi, Uveka. We are all hoping for that, Uveka. I have a guest from the Taxi Association, Amsterdam Taxi Association, Mr. Tladi Lipolisa. And what did I write here? Sure, guys. Let me change your name.
Your officials against yours here, yeah?
I sent it. Hey Joe, go on to say that this thing. You know if you have
Can come already.
Good afternoon, Uveka. Well, we have spoken to a couple of people and we're on the ground earlier on Lillian Ngoyi Street. Yes, work is being done. We have seen people at work and it looks quite different, I must say, which the CEO of the Johannesburg Road Agency spoke to earlier on, saying they're going for a different look, a different feel from what you see on the freeway, and they are basically reinventing how the place looks. But now there are many aspects when you talk about Lillian Ngoyi Street. Of course, businesses in and around the street were also affected, but the people who were also affected the most are the public transport people, the taxis, and that is why we are here right now. We are at Amsterdam Taxi Association to speak to the Taxi Association to how the local taxis were also affected by the explosion. I am joined by Mr. Tladi Lipolisa from Amsterdam Taxi Association right now. Sir, thank you so much for joining us. Now, we know the gas explosion has affected local transport. Can you talk to how the closing of Lillian Ngoyi has affected the taxis?
Thank you very much. Yeah, it has affected us greatly because with us, time is money. So you have to understand, once you've got traffic congestion, then we're losing out. So since it's been closed, we've not been making any profit.
Yeah. So now there has been a tumultuous, they've been postponing the fixing of the streets, and now the city is promising that this Friday they are going to open the street. From what you have seen and from the work that you have done, you have seen being done, are you confident that this time the city will actually open up?
I'm not convinced. Actually, I think it was prematurely announced. But we have to be optimistic. We'll just have to hope for the best. Yeah.
And when you're looking at it, why are you not convinced? Are you not confident by what you are seeing, the work that's being done?
Yeah, there's still a lot to be done. Even now, what's partially opened is not properly done. Even the paving, you can see that it was not clearly properly done. Yeah, even the parking, there's no parking there. So it's still causing that traffic congestion that we were lamenting about.
Yeah.
Yeah.
And the new model of the street, the design with the opening of the walking spaces, how is that treating you guys as the public transport people?
We don't have a problem that much against that, but you'll have to understand they minimized the street in order to cater for the walking space. So yeah, traffic is still going to be there. So I doubt if our problems are really solved.
Yeah. And as the public transport people, if you were to speak right now to the city, what would you suggest?
I would suggest that they need to create more space in and around the city, and they must also deal with the dilapidating state of the taxi rank, especially MTN, Jack Minsa. That is a ticking time bomb. We've always been saying that to the city, that please help us. We want to move out of the taxi rank, because anytime that thing can collapse, and definitely we won't be covered for that. Yeah.
All right. Thank you very much, sir. That is from Mr. Tladi Lepolisa from the Taxi Association, Amstar Taxi Association, just talking to the reconstruction, or rather the rehabilitation of Lillian Ngoyi, speaking about space and the space that is already opened. He is saying they are not satisfied about some of the adjustments there, but also hoping and being optimistic that by this Friday, everything will be opened in order for the taxi economy to also be freely flowing. Okay. I think it was popping. Was it popping out? But when you come to adjust were they on audio or what?
I didn't hear it. You did transfer. I didn't
Just fit the wire in the center.
Yeah, but they sharp. Now you can.
So they had.
No, they were on the audio.
Oh.
Oh.
Okay. Thank you so much, sir. Yeah.
Send you the
Yes. And also anything maybe as a taxi, as the taxi association that you would like to voice out your opinions on when anything happens. You can just also text me about it, and then we'll talk. Yeah. But thank you so much for making some time for us today.
The schemes on? Hello? Hello?
Let me pass to
Hello?
washing us like
Phela kulosithathu sifaka under pressure because nginamathikithi mina manje kumele nginiphe wona, and we need to sort out ukuthi suhamba kanjani sihlele, you know. For the meeting, yes, I understand there it's fine. Knowing ukuthi imali zizanini, yes, we can do that ngaleso sikhathi, but ngoba manje ngifela ukuthi nisondele and then sizokwazi ukubona ukuthi abubani bazokwazi uku-attenda le event on Saturday. Please, yeah. Vela nisondele nge. Yeah, sikwazi ukuhlela. Yeah, Hannah.
It just depends on the time of the day. When the sun is completely aligned with our planet. Whatever the study, what the same experiences, and then the good days, the timing, the day, what you the day that you can start here. Sometime last quarter, and this year, no I'm waiting.
Now, you know what? It works in our favor now, because once if there is a Saturday, it will cost not too much. And Friday, I get what's my night. Friday. Member will please come from Monday, Tuesday, Wednesday, and then come every Friday. Yeah. No, so